All right, now we're going to turn it over to more, I would say mundane, but actual the things that the Lawyers Committee is doing. And we're doing some very important things. And here's a freedom fighter, Mick Harrison. I don't know if they want me to call him a freedom fighter, but I think he is a freedom fighter in the same generics as a Patrick Henry. And all the Lawyers Committee are like that. And as we said, Ed Asner was like that. We're patriots. We want our country back. We want the Constitution to be filed. Now, Mick is he's one of the top whistleblowing attorneys in the country. And we're fortunate enough that he is our litigation director. And he does a marvelous job putting and drafting a lot of our actions. So, Mick, take it away. Thanks for being here.
Thank you, Dave. So it sounds like I've been promoted to director of the mundane. Just kidding. So to follow on a thought that Dave just ended with about the truth, one of my favorite quotes from a judge, federal judge, is, it's a short one, "The truth is worth the trouble it takes to find it." And our approach at the Lawyers Committee, we call it a campaign approach, is to use the law as a tool for promoting truth and justice, transparency, and accountability. That doesn't mean that all we do is lawsuits, though. The campaign approach involves not only litigation, but investigation, public education, work with the media, work with Congress when appropriate. So we're trying to use a combined approach, different strategies in an intelligent combination to achieve the goal. So what I'll try to give you now in the short time I have is a summary of our major legal actions to date. The first one I'll talk about, many of you know about at least how it started. You may not know how it is proceeding. We did file a petition with the U.S. Attorney in New York, Southern District, and it compiled a huge amount of evidence showing compellingly the demolition of 3 World Trade Center buildings on 9/11. Now, even though the U.S. Attorney assured us that he would follow the federal statute that makes it mandatory for that report of a federal crime to be given to the grand jury, we never got a confirmation, even though we asked, from the U.S. Attorney that the grand jury had been given our petition and the evidence. So that brought us to file a lawsuit in federal court in New York. It's a Mandamus Act and a Administrative Procedures Act lawsuit. We sought an injunction to compel the U.S. Attorney to give our petition and the evidence to a federal grand jury. The district court unfortunately decided that the plaintiffs, which included some 9/11 family members and some first responders, in addition to the Lawyers Committee and architects and engineers, that none of us had legal standing to pursue the case. The district court didn't say we were wrong about the evidence, didn't say we were wrong about the duty of the U.S. Attorney to give the evidence or the report of the crime to the grand jury. In fact, more the contrary on that. But the district court was not willing to issue the injunction because of the standing issue. We have appealed that decision to the United States Court of Appeals for the Second Circuit. I filed our reply brief yesterday, and we are hoping to get oral argument on that soon. So we'll let you know how that proceeds. One detail that I found disturbing in the government's brief to the Second Circuit was that the government is now saying in writing publicly that citizens of the United States do not have a right under the First Amendment to petition a federal grand jury. And we'll see how that case goes. We're certainly going to do our best to win it. I'm cautiously optimistic that we will win it. We certainly should win it. We'll keep you informed. Second major project, which has 2 parts, has to do with the anthrax attacks. Some of you, like me, lived through that time period. It came on the heels of 9/11, literally 1 week after the 9/11 attacks, the anthrax letter mailings began. Most of you probably know by now we did do a petition to Congress on those anthrax attacks. It's very detailed. a lot of evidence summarized in a way similar to how we did on the demolition evidence in New York. We also explained the crimes involved to some extent, and the law that basically should motivate the Congress to start its own investigation. We have not heard back from Congress on that. We'll keep you informed. Today, we filed another major filing on the anthrax attacks. We did a petition to a grand jury through the U.S. Attorney, through the Attorney General, and the Department of Justice. And one of the concerning aspects of that grand jury petition is we also asked for a special counsel to be appointed. The reason we did that is that our petition goes into detail with a lot of documentation demonstrating that the FBI, and I'm trying to say this tactfully, engaged in misconduct in regard to the anthrax attacks and the investigation of it, literally covering up key evidence that would have pointed towards the source of the anthrax used in those attacks having been either a U.S. military facility or a U.S. military contractor. And as Dave has mentioned, Dr. Ivins was scapegoated by the FBI for those attacks. His untimely death prevented any trial on those crimes. And we believe it's time for a new investigation. And some of you may remember back in the 2008-2010 time period when the FBI was closing its investigation, that the New York Times, the Washington Post, a number of others, including some Congress people, called for a new investigation of the anthrax attacks. What you may not realize is that investigation never happened. So we're joining that chorus of calls for a new investigation in this grand jury petition. Now, we have done a number of FOIA litigations, 3 so far. We have a number in the works. FOIA meaning FOIA, the Freedom of Information Act. Most of you know about it. One of our FOIA cases done for David Cole, who's one of the most active FOIA researchers, FOIA filers on 9/11. We asked for the data regarding the National Institute of Standards and Technology World Trade Center 7 study, in particular regarding column 79, which is where NIST says the collapse of Building 7 began. Most of you probably have heard that Architects and Engineers has just filed a new lawsuit against NIST regarding the Building 7 study. I'm involved in that lawsuit as well. And NIST has kept their modeling of their theory that fires caused that collapse a secret from the public. They gave us the conclusion, but the details of their analysis is still a black box. So we're trying to cut through that. The first FOIA case we filed on that issue did not succeed. There was a statutory exemption involved, which was a roadblock to that FOIA case. And also there was a wording issue in how our request was worded. So we're going to go back and try to get that data through the Architects and Engineers lawsuit and probably another FOIA request. Our second FOIA suit has to do with interviews conducted either by NIST or given to NIST at the Trade Center on 9/11. One in particular was a witness that we have reason to believe witnessed explosions in Building 7. That lawsuit did not succeed, and the reason was, in regard to that particular key interview, is that the district court allowed NIST to offer a defense, a legal defense, an exemption under a statute based on a declaration by the head of NIST that did not exist at the time we made the FOIA request, when David made it, at the time the administrative appeal was filed by David, and at the time we filed the lawsuit. We're doing these lawsuits for David and support of David. And so late in the litigation, after the judge indicated he might be willing to release a part of that key interview based on this, how shall I say, unpersuasive argument on privacy concerns regarding a witness who's unfortunately now passed away, the NIST decided that at that point in time, it was going to offer a new legal defense, which was that the head of NIST had declared this particular interview to be subject to a statutory exemption. The problem is NIST had not made that determination until way after we filed the lawsuit. So it's a post hoc, after the fact rationalization, as I would call it. But the district court allowed NIST to do that. And for that reason, that case did not succeed. Now, the third FOIA case, we've had more success to date. It's still pending. This was regarding the building performance study by FEMA. David asked for all the data used in that study. It was refused. FEMA initially said they didn't have any records, which was a bit of a mystery since they did a detailed study. How they could have zero records on data used in the study they actually did mystify us. But that was their claim. They then later explained when we sued them that they'd given all of their records, FEMA had given all of its records on their study, FEMA study, to NIST, and had kept nothing, which meant they didn't keep any emails, they didn't keep any email backups, they didn't keep any hard drives, go down the list. They basically said they gave NIST every piece of paper and electronic file they had on that study, which basically couldn't have happened. So we pursued with the litigation. Summary judgment motions were filed by both sides. The matter was assigned to a magistrate judge by the district judge. The magistrate judge has issued a decision in our favor, recommending to the district judge that FEMA and NIST motion be denied and that our motion for discovery be granted. We're expecting the district judge to make a decision on the magistrate's recommended order any moment. We were hoping it would be issued by now, and we'll let you know as soon as that happens. But that case is moving in a very positive direction. We will be doing a more ambitious FOIA campaign if our resources allow after the anniversary, and we'll keep you informed on that. Now, we did file a lawsuit in Washington, D.C. against the FBI and the DOJ. It related to the 9/11 Review Commission, which some of you know about, some of you may still not. This was not the original commission. It was a 2014-2015 follow-up commission mandated by Congress. And Congress asked and basically ordered the FBI to look at all 9/11 evidence that the original commission had not looked at. Well, we did the lawsuit to compel the FBI to look at all the evidence, because even though they issued a report, it essentially ignored the Saudi evidence, ignored the demolition evidence, go down the list, 7 categories of 9/11 evidence that was completely ignored. The district court there also decided, unfortunately, that we didn't have standing, including Robert McIlvain, a family member, and architects and engineers, and the lawyers committee. So we did appeal that to the U.S. Court of Appeals for the District of Columbia Circuit. Under some unusual circumstances, the Circuit Court of Appeals upheld the district court decision on standing. We have now petitioned the U.S. Supreme Court to hear this case, and we don't know yet. Our petition for certiorari is pending. But the short version of the unusual circumstances, our 3-judge panel on that case included Judge Mary Garland, who you probably know now has become the Attorney General of the United States. So while we were suing the Department of Justice, Judge Garland, who was to become the head of that agency, was on our appeal panel. He participated in a decision, a preliminary decision in our appeal, which denied oral argument to us, even though it had already been scheduled, which probably led to the decision being issued as an unpublished decision, which caused it to get less fanfare. And it appears Judge Garland recused himself after that point and did not participate in the final decision. We asked for a disclosure from the court on the details of Judge Garland's participation and what he knew when about his at least appearance of a conflict of interest. And unfortunately, the Court of Appeals declined to give us any disclosure. So that is now one of the issues before the U.S. Supreme Court that we hope the court will hear on the merits. So in terms of our future legal actions, and there's more I could say about our anthrax petitions and our lawsuits, but to try to get us back on our time schedule, on our future legal actions, we will have an ambitious FOIA campaign. we are contemplating a major federal lawsuit, and I'm not speaking for the board yet, but I'm the person who will be advising them, and I'm thinking about the potential for a major federal lawsuit that will focus on government cover-up or cover-ups regarding 9/11 evidence. That could include the demolition evidence, the Saudi evidence, and we might add to that list. It'll be up to the board whether we go there, and probably up to you all whether we get enough support in terms of donations and volunteers to do that. We are contemplating, as Dave mentioned, additional investigations in a number of areas, additional grand jury petitions. We are looking seriously at a pattern of FBI and intelligence agency misconduct regarding 9/11, and we expect to be completing an investigation and doing reports on that, possibly a lawsuit as well. So as I'm sort of, well, maybe I'm closing up. We'll see how much time I get here. A quick note about conspiracy theories. My experience in 30 years as a lawyer, a public interest lawyer, doing whistleblower cases, suits against the government, I can tell you, unfortunately, that not all conspiracies are false, and some alleged conspiracies are real and can be proven. I've proven a few in my time, and we've proven some in regard to the anthrax attacks and regarding 9/11. So, when folks tell you, all folks who adopt a conspiracy theory are, how shall I say, misguided, deluded, all I can tell you is that some conspiracies end up being proven, and they can be very serious ones. There's an old military saying, I'm probably not quoting it, to the effect that the artillery shell you need to worry about is not the one you see and hear coming, it's the one you don't see that kills you. So my approach to conspiracy theories is you need to follow the evidence and evaluate the evidence. You shouldn't blindly accept a conspiracy theory that's alleged. You shouldn't blindly reject a conspiracy theory that's alleged. You just simply look at the evidence and follow where the evidence leads. If the theory can't be proven, then you reject it. If it can be proven, you shouldn't be ignoring it, because if you do, it may be to your peril. Some of the speakers you're about to hear are going to talk about the pandemic, and you may wonder, why is that topic on a lawyers committee for 9/11 inquiry agenda? The short answer for me, and I'll give you my opinion, is that there is a potential overlap that in our investigation isn't finished on this. We did do a detailed investigation of the anthrax attacks. We have concluded, although our inquiry continues, that the follow-on anthrax attacks are related to the 9/11 attacks. And you'll hear more about that. But the anthrax attacks involved a biological warfare agent attack on the United States Congress and on the free press. There have been reports from scientists and researchers that there's hard evidence that the COVID-19 virus was genetically engineered. I don't know if that's true. I'm willing to look at that evidence. The point is, if it is true, and there was genetic engineering to do the gain of function thing to make the virus more deadly in one way or another, then that virus may be, in fact, something created as a bioweapon. And if the U.S. biowarfare program folks, officially or unofficially, were involved in that, and as it appears, were involved in the anthrax attacks, which are related to 9/11 based on our inquiries, then further inquiry is justified. So, no conclusions on that yet. We do need to look at the evidence. We'll be listening to the speakers and forming our opinions later after looking at all the evidence. So, with that, I'll close my presentation as a reminder. We are a law and evidence-driven organization. We do use a campaign approach to promote transparency and accountability, not just litigation. You'll be hearing a little more from Bill Jacoby, one of our board members, on non-litigation strategies. So thank you for your attention. And Dave, I'll turn the program back to you.
Thanks, Mick. As Mick mentioned about the conspiracy, doing criminal work conspiracy to commit a crime, whether it be to sell drugs or to commit a robbery or to even murder someone. It's a very common crime. There's, statutes are filled with conspiracy. So when somebody tells you a conspiracy theory, criminal laws is filled with conspiracy laws. All right. So it's just something to belittle people. But as Mick said, if you follow the evidence and you've got something tangible to connect it to a crime, well, it's a conspiracy to do whatever that evidence is telling you. Thanks a lot, Mick.